Magandang araw po sa inyong lahat. Nawa kayo ay ligtas sa nakaraang bagyo at nasa mabuting kalagayan sampu ng inyong mga pamilya. Patuloy po tayong magdasal at mag-iingat sapagkat may mga paparating pa pong bagyo at tayo ay nasa loob pa rin ng pandemya dulot ng COVID-19 disease. Ito pong muli ang inyong Juris Doctor sa ating segment na Tidbits of Labor Laws para sa isang napapanahong paksa na may malaking epekto sa mga manggagawang Pilipino. Ito po ang extension of floating status of workers from 6 months to 1 year. The Department of Labor and Employment extends floating status of workers from 6 months to 1 year. The issuance shall take effect 15 days after its publication in a newspaper of general circulation. It was signed on October 23, 2020 by Secretary Bello. It was also published on October 27, 2020, thus it will take effect on November 11, 2020. Please take note na ito ay epektibo pagkatapos ng 15 araw mula nang ito ay mailathala sa isang pahayagan o dyaryo na may pangkalahatang sirkulasyon. Ito po ay nailathala noong October 27, 2020 at magiging epektibo pagkatapos ng 15 araw o sa araw ng November 11, 2020. Ayon po sa DOLE, ang extension na ito ay upang maiwasan ang tuluyang pagkawala ng trabaho ng maraming manggagawa, bunsod pa rin ng epekto ng COVID-19, kung saan maraming negosyo ang nagsara at nakaamba pang magsara dahil sa pagkalugi ng negosyo. Ito rin daw ay isang paraan upang makatulong din sa employers upang makabawi sa kanilang pagkalugi. Sa kabilang banda, pinangangambahan naman ito ng sektor ng mga manggagawa sapagkat maaari umano itong maabuso ng employers upang maging kasangkapan sa union busting at iba pang unfair labor practices. Ayon sa bukluran ng manggagawang Pilipino, wala di umunong measures in place ang DOLE para maberipika kung ang extension ng suspension ay sadyang kinakailangan para maisalba ang negosyo ng isang kumpanya. Ano nga ba ang nakapaloob sa Department Order No. 215 Series of 2020? Ito po ay ang rule na binago ang Section 12 of Rule 1 Rules Implementing Book 6 of the Labor Code on Employment Status. Simplehan po natin para mas maintindihan ng ating manggagawang Pilipino. Ito po ay ang extension o karagdagang 6 na buwan na maaaring mailagay sa floating status ang isang worker o empleyado. Hindi po lingid sa kaalaman ng lahat na ang floating status ay epektibo lamang sa loob ng 6 na buwan under Section 12 Rule 1 Book 6 of the Labor Code of the Philippines. At dahil nga po sa Department Order 215, hindi na lamang 6 na buwan maaaring mailagay sa floating status ang isang worker. Pagkus 1 taon na po mula nang magdeklara ng pandemya noong March 15, 2020 ang ating gobyerno. Dahil nga sa karagdagang 6 na buwan ayon sa DO 215-2020. Ito po ang nakapaloob sa Department Order 215-2020. Number 1, Amended Rule on Suspension of Employment Relationship. Section 12 of the Omnibus Rules implementing the Labor Code is hereby amended as follows. Section 12, Suspension of Relationship. The employer-employee relationship shall be deemed suspended in case of suspension of operation of the business or undertaking of the employer for a period not exceeding 6 months unless the suspension is for the purpose of defeating the rights of the employees under the code and in case of mandatory fulfillment by the employee of a military or civic duty. Ayon po sa Rule or Section 12, ang employment relationship o ang employer-employee relationship ay maaaring masuspinde sa hindi hihigit sa 6 na buwan kapag may suspension sa operasyon ng business, subalit ang suspension ng 6 na buwan ay magiging illegal kapag ang purpose nito ay ma-defeat ang mga karapatan ng mga manggagawa na nakapaloob sa Labor Code. The payment of wages of the employees as well as the grant of other benefits and privileges while he is on a military or civic duty shall be subject to special laws and decrees and to the applicable individual or collective bargaining agreement and voluntary employer practice or policy. Maaari din itong masuspinde in case of mandatory fulfillment by the employee of a military or civic duty. In case of declaration of war, pandemic, and similar national emergencies, the employer and the employees, through the union, if any, or with the assistance of the Department of Labor and Employment, shall meet in good faith for the purpose of extending the suspension of employment for a period not exceeding 6 months, provided that the employer shall report to the Department of Labor and Employment through the regional offices the extension of suspension of employment 10 days prior to the effectivity thereof, subject to inspection. Provided, however, that the employee shall not lose employment if they find alternative employment during the extended suspension of employment, except in cases of written, unequivocal, and voluntary resignation. Provided further that should retrenchment be necessary before or after the expiration of the extension of suspension of employment, the affected employee shall be entitled to separation pay as prescribed by the Labor Code, company policies, or CBA, whichever is higher. Provided finally that the retrenched employees shall have the priority in rehiring if they indicate their desire to resume their work not later than 1 month from the resumption of operations. This notwithstanding, by mutual agreement of the employer and employees, through the union, if any, or with the assistance of the Department of Labor and Employment, employees may be recalled to work or retrenched, subject to the requirement of notice and separation pay any time before the expiration of the extension of suspension of employment. The extension of suspension of employment shall not affect the right of the employees to separation pay. The first 6 months of suspension of employment shall be included in the computation of the employee's separation pay. So, malinaw po yun. Kasama po yung first 6 months sa pag-compute po ng separation pay ng isang empleyado. Okay, para mas malinaw, iisa-isahin po natin ang mga requirements na nakapaloob po sa DO 215-2020. First, ang employee at employer ay mag-uusap in good faith para sa extension ng floating status na di lalagpas sa 6 na buwan. Second, ang employer ay dapat mag-report sa tanggapan ng DOLE 10 araw bago ito ipatupad subject sa inspection ng DOLE. Pangatlo, tandaan na ang empleyado ay di maaaring tanggalin sa trabaho kung sakaling makahanap siya ng alternatibong trabaho sa loob ng extended suspension of work maliban lamang kapag mayroong written and unequivocal resignation ang empleyado. Pang-apat, kapag di maiiwasan ang retrenchment, bago o pagkatapos ng expiration ng extension ng suspension of employment, ang epektadong empleyado ay dapat makatanggap ng separation pay alinsunod sa Labor Code, company policies or collective bargaining agreement kung alin man ang mas mataas dito. Ikalima, ang mga empleyado na na-retrench sa trabaho ay maaaring maging priority na maibalik sa trabaho kapag isinaad nila ang kanilang kagustuhang makabalik sa trabaho na di dapat lumagpas na 1 buwan mula sa pagbabalik ng operasyon ng kumpanya. Gayunpaman, sa pamamagitan ng mutual na kasunduan ng employee at employer through the union, kung mayroon man, o sa pamamagitan ng assistance ng DOLE, ang mga empleyado ay maaaring maibalik sa trabaho o maaari ding ma-retrench sa trabaho subject to the requirement of notice and payment of separation pay anumang oras bago ang expiration ng suspension of employment. Number 2, non-diminution of benefit. Nothing in this issuance shall be considered to authorize or justify the diminution or reduction of benefits, supplements or payments as provided in existing laws, individual or collective agreement, or employment practices or policies. Number 3, compliance and enforcement. The DOLE regional offices shall inspect and monitor the proper implementation of this issuance. Number 4, repealing clause. All policies, rules, orders, and other issuances inconsistent with the provisions of this issuance are hereby repealed or modified accordingly. Number 5, transitory provision. This issuance shall not apply to cases already filed at the time of the effectivity thereof. And number 6, the effectivity. As already mentioned, this issuance shall take effect 15 days after its publication in a newspaper of general circulation. 23rd October 2020, signed Silvestre H. Bello III, Secretary of Department of Labor and Employment. Maraming salamat po sa inyong pagtangkilik sa aking channel na Juris Doctor Diaries. Nawa kayo po ay may natutunan sa ating topic ngayong araw na ito. Mag-comment lamang po kung kayo po ay may mga katanungan at sasagutin ko po ito sa abot ng aking makakaya. Hanggang sa susunod na tidbits of labor laws, ito po ang inyong Juris Doctor nagsasabing mag-ingat at maging healthy palagi. Thank you! Bye-bye!